My name is Roland Mumford with Mumford Law. Today, I wanted to do a video to help you learn how to demand and preserve documents, evidence of police misconduct, what we refer to as spoliation letters, preservation of evidence letters, and records requests through Open Records Acts. But for a moment, I just want to say thank you very much for all the views and the subscribers that have joined my new YouTube channel. We finally had a video that took off and seems to be going a little bit viral, and thank you so much. I do want to say that I only litigate cases in Arkansas, Tennessee, and in Georgia, and I've been getting calls and emails from other states today. Those are the only three states that I litigate in. If you need a Section 1983 attorney, do a Google search, particularly in a larger city in your state, and put in Section 1983 civil rights attorneys, and there should be some people that come up. Now, getting back to what I wanted to do this video about today. I think one of the reasons that video took off last night, it was the video about how police officers harassed me into a civil rights litigation practice. The feedback that I've been getting is that it was the authenticity and the sincerity behind the content that has propelled that video to now around a few thousand views and a few hundred subscribers. And I'm hoping that will be several thousand views this evening. And my goal of reaching that 1,000 subscriber mark within maybe a month or several weeks. So let's get to what we were talking about today. Let's say you have a situation and you have a police misconduct situation. Perhaps maybe you have a traffic stop and the police officer, through a false notion of an arguable, articulable, reasonable suspicion, wants to arrest you. Or maybe you're on property, something occurs. False arrest, excessive force, malicious prosecution, there's all types of claims in 1983 law. But everything that usually begins from a document request that you would want to get from that police department or the government agency. So again, as I said a moment ago, I come across much better on camera when I'm speaking unscripted and without a teleprompter, and I'm going to try that again today. I think for the employment discrimination videos, we'll probably be a little bit more scripted because of the technicalities. So how do you get body cam video? How do you get the documents that you need, and how do you make sure that they're not going to be deleted? That is extremely important when you have a situation after an incident of police misconduct. If you call a lawyer's office, one of the very first things they're going to ask is there body cam video? And that's one of the reasons that I enjoy Section 1983 litigation, is because it doesn't involve all the he said, she said often that you see in employment discrimination. So let's say you've been falsely arrested and you've bonded out and you believe that there's been misconduct and you want the evidence to demonstrate what occurred. The very first thing that you want to do is utilize open record statutes. And you want to get common law, or what we refer to as using it like a spoliation letter, preservation of evidence demand letters. And that's what we're going to get into today. There are state open records acts or known as public records acts. And I'm going to give some case examples, but I have to intentionally keep it a little bit ambiguous as to the specific facts, so I can give the general point across. You want to get a spoliation letter and a records request letter to the police department or a government agency immediately. And the Open Records Acts, let's start with that. There are Public Records Act laws in every state that allow a citizen to demand public records from any government agency. Now, often what can constitute a public record will be itemized in that statute. However, there will be exceptions listed in that statute that will prevent you from getting those records. Now, what kinds of exceptions are there? One could be the investigation exception. I get that all the time. One of the things that I always ask when somebody calls my office is, have the charges been dismissed? Because under a Supreme Court case law known as HECK, H-E-C-K, you can look that up, there has to be a favorable outcome in your criminal court case for you to have a Section 1983 case. Most attorneys are going to take cases where all of the charges were dismissed. So often a police department will not produce the records requested because they will claim there's an investigation exception in the Open Records Act. meaning if the investigation is going on, then they don't have to produce the evidence, such as the body cam video, CAD reports, incident reports, or so forth. You might be able to get the CAD reports, but many of the documents are going to claim that they can't be produced. And that is a very hard exception to overcome. Now, in Tennessee, for example, criminal court cases move through general sessions very quickly, ultimately to a disposition. They don't sit around for several months, a year or two, like they do in Georgia, because in Georgia, prosecutors have a certain amount of time to litigate a misdemeanor case, which I believe is a year or two, and then they have a few years to litigate a felony case. And so that case, that investigation exception, can be used for a very, very long time. Another exception that they will try to say is sensitive images such as children in the video or photos or other digital media. If it has, I just had this come up. A local police department tried to say that they couldn't produce the body cam video where the police officers had gone inside of the house. I went back to look at the Tennessee Open Records Act, and that was correct. There was an exception for that. That was a bit frustrating. Obviously, other information, things that are sensitive material, such as intimate related things, and I obviously don't want to go into that in detail. Personal information is going to be redacted from those documents: police officers' addresses, social security numbers, phone numbers from their personnel records. Any kind of personal identifying information about really anybody will be removed. There are numerous other exceptions that are listed in that statute. Now, there can be a charge for these documents. Very oftentimes, these police departments or government agencies, they will absolutely lie to you about what it costs in terms of preparation time to get those records or get that video or copy the documents, etc. But usually there's a set rate in many of these open record statutes. Recently, I just had a case down in Georgia. It involved a case that was all over the news where a police officer took a 13-year-old child off of the bicycle, threw him down to the ground, and assaulted him. That's on my website, and you can look it up online. My clients, when they had initially started to do the public records request, the bill for that, they claimed it was going to be over $400 to get all the documents necessary. Fortunately, I have a friend that has another YouTube channel in Georgia, and he's an open records expert, and assisted her to get that down to a little bit over $100. So do not allow government agencies or police departments to lie to you and take advantage of your ignorance of the law, because they sometimes know that people will not pay the money to get the records. Usually they will issue the records and then submit an invoice, but sometimes they'll submit an invoice before they produce the documents. Now, we've been discussing about open record statutes. I want to talk about a little bit more detail about what is a spoliation letter. That's often what I refer to it as. Many people refer to it as an evidence preservation request, where the person, whether it's a private person or a business or a person that works for the government entity or the government agency, when they receive a letter that demands that evidence be preserved, then under law, either by statute or by common law, which is judge-made law, basically, they have an obligation through reasonable efforts to protect and preserve those records. So right now, for example, I'm dealing with another case in South Georgia with a person that was assaulted by an officer, and it's a pretty interesting case. And one of the issues in that case was there's a gas station, McDonald's, and there was a camera literally right over where the incident occurred. So we're getting the public records from the particular sheriff's office, and I commend the professionalism for the young lady that's been assisting me with that. But the business where this occurred, and you will often get this excuse from a private entity, is that, well, they understand they have an obligation to, let's say, preserve the surveillance camera video, but they won't produce it absent a subpoena. Well, the issue with that is, how are you going to get the subpoena without first filing a lawsuit? And obviously, we don't want to file a lawsuit unless we have the evidence. So it's sort of a chicken or the egg situation. And if you ever have to submit a letter about what we're about to discuss, I'm literally going to, in the description link to this video, it might be a little bit later today, I'm going to put in a Dropbox link to a template document that you can submit to preserve documents and do a public records request. It'll be a basic template, but it'll get you started, and that'll be in the description. I'm going to read through that here in just a moment and kind of give you an idea of what would be in that letter. So, in that situation, there actually is another situation, funny enough, involving a McDonald's. Many of these types of businesses, you can have a person or yourself go in there, give them the letter to the manager. However, many of these businesses, you're dealing with a fast food place or whatever kind of business it may be, and you can't necessarily rely on that manager to do what it is they need to do and get that letter up to the corporate chain, such as human resources or some kind of operational manager that will take that letter more serious. But obviously, you want to do something. You go into that type of store, you ask for the manager, record yourself with your cell phone camera doing it so that there's proof. Give it to them and hope for the best. Now, something else you can do, though, is find out who owns that business. And if it's let's say a McDonald's or some other fast food type of place, that's usually going to be owned by a franchise owner. You got to figure out who is the business that owns the franchise. And then you got to locate that business, get their business address, and either call them or, email them or send them a letter certified sending that letter. And you want proof that they had received it. Call them as well and ask who is the person that would be responsible for that. And if you're in a one-party consent state, you can record that call without giving consent. But look up your state law on that. All right. So let's talk about how a letter would start out. In our spoliation letters and records request letters, obviously we introduce our firm, we identify the client that we represent, we state the nature of the incident that was involved. Now, in your letter, you want to say a general description of what occurred so that the person, if they're looking on the camera video, they sort of know what to look for. Obviously, in this recent letter that I sent to this particular gas station / McDonald's, we said this is where the car was parked. It was in front of the store. We can see from Google Maps that there's 4 cameras, and it should be either one of these 2 cameras. That's going to help the person narrow down which camera, which had the field of view. If you are looking for a very specific document or a specific email, try to narrow it down as to time, date, place, and manner, what information that you have about that document that they can narrow their search. Now, as we go further into our letter, we actually cite for that particular state, we will state the common law or the statute that requires their obligation to preserve the documents. And that is very, very important that you do that. Now, one general paragraph that you could put, for example, in the letter, we have, for example, this is a demand that you preserve the following and provide a copy which includes, but is not limited to the following: all documents, videos, and then in parentheses, we would state body camera video, dash camera video, or any other recording device. Audios, recordings, whether any other documents, tangible or intangible, electronically stored information. And we kind of go a little bit crazy explaining what kind of audio or video recording it might be. Now, we also state that we state the address of where the incident may be as well. The demand is for all video recordings, for example. Demand is for all audio video recordings captured by all officers and police cars on scene. Now, if you can get a copy of the incident report or use of force reports before you try to ask for the video, that is how you're going to know what officers were involved on the scene, and then specifically say, here are the officers we know to be there, and we want the body cam video from these particular officers. But always put in a catch-all phrase in your letter for any and all people that were on scene, all officers on scene, employees, etc. Another paragraph that you would want to put in there: any documents, electronic communications, case file, investigative file, court file, and or reports, and any other records and documents prepared and or maintained by your department concerning the incident referenced above. Another general request that you will want to request is all standing operating procedures, or what we refer to as SOPs. Another phrase is standing orders. Any and all policies, procedures that those officers relied upon in doing what it is that they did and that they're relying upon as a basis for what they claim to be a legal arrest or use of excessive force or prosecution. So you also want to ask for all standing orders, policies, procedures maybe going back for the last 2 or 3 years, because there could have been revisions and changes. Don't do a request for just the last 12 months. You also want to put in a statement that please produce these records, for example, 7 to 14 days from the date of this letter. Include a copy of an itemized invoice that you'll pay. Put in a nice statement. Thank you for the time, effort, consideration, and requests. Now, there's some other important statements that would go into such a letter. For example, a paragraph that would say the destruction, alteration, or loss of any of the below constitutes a spoliation of evidence under law. We specifically request that the requested evidence be maintained and preserved and not be destroyed, modified, altered, repaired, or changed in any manner. And further, that you immediately put any third party vendor that has or controls this information, material, or documentation on notice to maintain and preserve without change. You want to ask for the personnel records. For personnel records, employment records of police officers are absolutely open records. Now, obviously, they will go through and redact personal information. But for example, we have the sentence: I am requesting the personnel files for the following employees, which are absolutely subject, in this case, to the Open Records Act, and redaction may only be for personal information. I list the individual officers' names. A lot of times you may only know a first name or a last name, depending on what you can see either on video or maybe what you remember seeing in person. Or you may know what the badge number is. That is why it is absolutely crucial. Every time you have an interaction with a police officer, you demand name and badge number. In almost every police department, as either a matter of policy or there may be a law that says they have to identify themselves to you. That's very important information, so you know what to put in the letter and who to identify to get personnel files from. Why is that important? Because in the personnel and employment files, that's where you're going to see history of complaints filed against that officer, reprimands. There may be other documents in there that came from other police agencies, maybe their post certification. We used actually in a deposition in a particular case recently where we caught a person in a police department lying in the deposition about not having a criminal record. And we had the employment file right there pulled out and said, no, you checked off yes here. So that was actually the one time I wish we had had video recorded the deposition. That is the nature of doing a spoliation letter combined with a Public Records Act request. Attorneys use Public Records Act laws every single day as pre-discovery to get evidence to investigate the merits of your case. I really appreciate the opportunity to build this channel. I really appreciate your views. Thank you very much for your time. Please share this video, click like and subscribe. You can visit us at mumford.law, and thank you very much for your time. Have a great day.